Good afternoon and welcome. Thank you for being the last panel of the day. So hopefully others will join us shortly. In any case, we have a very jam-packed session here. We'll be discussing the unique issues that are happening in EB5. Just very briefly, for those who are new to EB5, don't worry. We have a mixed panel, so we will be discussing the basics and then going into more intricate topics. Very briefly, my name is Rebecca Singh. I've been with Mona Shah & Associates for the last 5 years, focusing on EB5 and other areas of immigration. I'm very honored. To my left, I have very experienced immigration practitioners here with me. I'm just going to hand it over and let everyone briefly introduce themselves.
Hi, I'm Jinhee Wild, Principal and Managing Partner of Wild & Associates. Our firm focuses on employment-based immigration for about 99% of the time. And EB5 and other EB categories. I've been practicing for 16 years in immigration focus, and before that as a corporate and transactional lawyer, and started my legal journey as a prosecutor in Chicago. So I have quite a bit of a government bent to my thought process.
Hi, I'm Jeff Carr. I'm President and Senior Economist of Economic and Policy Resources. We're applied economics firm. EB5 is about half of our project work. If you're interested in EB5, we can help you, obviously, with the job and economic impact analysis. It's a jobs program. Got to count the jobs. We also do EB5 project business plans. We also can help you obtain a regional center. We do regional center business and operations plans. We do studies of geography for the area that you want to capture. And then if you want to make your regional center bigger, we can also help you develop a case for capturing more land for your regional center.
My name is Matt Verkstis. I'm currently with Greenberg Traurig in Washington, D.C. area. Prior to that, I've only been there for just about a year now. Prior to that, I served for almost 9 years as senior counsel to Senator Patrick Leahy on the Senate Judiciary Committee, and the EB5 program was one of the issues that I handled, and so worked on that between 2005 and 2013 when I left. So I come at it from a sort of the policy side of things.
It's all his fault.
Hey, good afternoon, everyone. My name is Julia Park. I'm the Managing Director of EB5 Group. We are a group that owns and operates 4 regional centers in the United States: New York, Northern California, Nevada, and Hawaii. But we are based in New York, and most of our projects up to this point have been in New York. Separately, under a different umbrella, I'm the president of Multivista Securities, which recently received FINRA approval to be a broker-dealer focusing on private placements.
Good afternoon. My name is Crystal Osman. I'm a partner at Miller Mayer in upstate New York. I represent a large variety of regional centers, developers, EB5 investors, both through the regional center program and direct investors. I also have a pretty robust general immigration practice in addition to representing EB5 investors.
My name is Reed Thomas. I'm with a company called NES Financial. We're the largest provider of fund administration and escrow services in the EB5 space. We partner with banks to do this, a number of banks across the country. We probably have a unique perspective in that we see a large variety of projects. We've been involved with over 450 now, about $20 billion in EB5 capital. So we've seen projects from the smallest of the small to the largest of the large, everywhere from $500,000 worth of EB5 single investor projects to projects raising close to $1 billion in EB5 capital.
All right, great. Thank you. So let's begin. As we know, Matt, the EB5 program is not new. It's been around for a while. So can you let us know, how has the EB5 program progressed throughout the years?
Sure. Yes, it is not new. It was many of you may know, or all of you may know, that the program is sort of it is two components. There is a permanent EB5 category in the immigration law, and then there's the regional center program. The original program was enacted in 1990 as part of the Immigration Act of 1990. What I understand is a couple years later, in 1992, Congress was trying to spur some additional activity in that category after enacting it, and I think not seeing a lot of activity for a couple of years. And so the Regional Center Pilot Program was enacted. It used to be called the Regional Center Pilot Program in the 2013, or excuse me, the 2012 reauthorization. The word pilot was removed from the statute. But just a note of sort of legislative interest, the Regional Center Program is not codified in the INA. It lives in a fiscal year 1993 appropriations bill for the Commerce, Justice, and Science Appropriations Subcommittee bill, which funds the Justice Department. As you all know, INA back at that time was part of the Justice Department. So, one of the things I think we'll see going forward is we will see the regional center, assuming it gets reauthorized and extended for more than sort of the 6-month, 1-year fits and starts. I think we will see legislators codify it in the INA at that time and really sort of clean up the legislative situation in the books anyway. But yeah, it's when I started working for Senator Leahy's office, it was Vermont had discovered it in 1996, I believe, 1997, and applied for status. The program was a very, very small piece of the immigration system. I sort of felt like when I was working back in 05, 06, 07, I was the only staffer in Congress who knew what the hell it was.
There's only 2 staffers at USCIS.
That's right. I remember Crystal's colleague Steve Hilaire coming up to the Hill all by himself and sort of trudging around and trying to sing its praises and talk about it, and so we had lots of conversations back then. But as you guys all know, and certainly the folks that use the program know, in 2008 things really took off, and in addition to the domestic side growth we've seen in the program, certainly the various service industries overseas and domestically have also grown proportionally to the rest of the program, and so the last few years have seen a fully subscribed program, and would anticipate that we will continue to see that. But just tremendous growth. I mean, by the time I left in the Congress in 2013. This was a real program, and far more members of Congress were paying attention to it and caring about it. So that's for better and worse.
Great, thank you. So just to break it down a bit, there's 3 different types of projects that investors can go into. You have your entrepreneur visa, which is the one that's permanent, and that you can invest into your own project and create 10 direct jobs. Then we have the regional center project that you would use someone like Jeff, who's the economist. He'll do economic analysis to see how many jobs can be created. And then from there, you can determine how many investors you can have in your project. The other one is the pool direct, which I've seen a lot more of those projects out there, where it's direct jobs, but the projects are able to take on more investors. So instead of the one investor as the entrepreneur project, it will be, it could be 15 to 80 investors, but they're creating direct jobs. So I want to ask the panel, as far as we see the Regional Center program is up for renewal in September, has anyone seen any increase in the entrepreneur visas? And if so, what issues are there with these? I know, Julia, you had some ideas on that.
Yeah, well, let's take a step back. Big fan of taking steps back. So a direct EB5, the entrepreneurial visa, is you create 10 W-2 real workers. A regional center program, you don't create real W-2 workers. You take the economic impact of the project, translate that into a job number. So you get to capture the economic indirect effects of a project, which means you have more jobs per project, which also means you can raise more money. So for real estate projects, you really have to go through a regional center. The third model that Rebecca was just talking about is, well, then what if I'm creating a factory and I'm hiring 150 people? That means 10 investors, 15 investors can get 10 jobs. So that's the pool direct. The issue with the entrepreneurial direct is that it takes right now for non-Chinese citizens 2 years to get a conditional green card. So it doesn't work. You're not getting a visa for 2 years. How are you going to come and create a business and hire 10 people? So direct EB5s one-on-one are virtually non-existent. I have done a few. Oh, I also have an immigration practice, which I don't really advertise, but so we have done a few, but those are cases where the people are already here on E2s or they're here on F visas, and on the side they just kind of hire a manager and don't get compensated and wait for their green card to kick in. So there are rare cases where that happens, but generally for people overseas, you just can't do direct EB5. So the third option is the pooled direct. The benefit of the pooled versus the regional center is that the program is not going to expire. The regional center program is a pilot program, and it extends every 3 years. It has never not been extended, but there's always that kind of concern hanging over the air. I mean, every 3 years, it's like, what's going to happen? With the direct program, it's a permanent program, so there is no concern. However, and I had a conversation with Rebecca about this, I'm not a big fan of direct projects, and this is why. When you have a regional center project and you're counting the indirect construction expenditures of a project, for example, $1 million in construction expenses put into New York in a project that lasts for over 24 months, on paper, theoretically creates approximately 12 jobs. So if you put $10 million into construction, you are anticipated to create 120 jobs. And once you have actually put that $10 million in, you have created the 120 jobs according to the program. So even with retrogression, people will not get their conditional green cards until 4 or 5 years from now, not get their permanent green cards for 8 years, but the jobs that they need to get the condition removed at the end of the I-829 period, the conditional removal period, is already there like 3 years into the 8-year timeline. So after the construction is completed, your jobs are secure, and then you just have to kind of wait it out until you can file. With a direct EB5, because you're counting the number of jobs at the point of your condition removal filing, which we call 829, the jobs have to be there 8 years from now if you're a Chinese investor. And what if the project changed? And there are just so many issues that a direct project can potentially have in terms of maintaining the business and showing the jobs 8 years later versus a regional center project where, at least in construction, if we count revenue expenditures, that's another story. I won't go into that. But at least compared to only a construction expenditure project, there is a lot of risk that comes from time. So that's, the main reason, not because I'm a regional center, but that is really the main reason that I'm a little bit of uncomfortable in the direct EB5 project in this era of retrogression because of the long timeline in which you have to wait to be able to show those jobs.
Okay. Well, Jinhee and Crystal, Jeff had a comment.
All the things that Julia says notwithstanding, all we can do is tell you about our own experience. And even though an economist isn't used on a direct EB5, there's still a business plan. And, with all the attendant W-2 wage reporting and I-9s proving that the positions have been occupied by someone who has legal status to work. Over the course of time, I would say up until last year, we wouldn't have more than 2 or 3 projects come across our desk in a year on direct EB5. Right now, we have 7 projects. So with the uncertainty in the regional center program and what might or might not happen to it and how long it's going to get extended, is it going to have another short-term extension, things of that nature, there are some folks, particularly for projects that involve operations jobs, as opposed very few direct job construction activity jobs, unless the applicant, the company doing it, owns a construction company or has a wholly owned subsidiary that's a construction company. But there's a dramatic increase in the interest in direct. I don't know if they'll actually go to market and be funded, but certainly people are looking at right now as an alternative to having no.
There's just so much uncertainty.
Yeah, without having the option of otherwise having no EB5 funding, some people now are looking at directs.
And I would agree with that. I think also too, there's a number of benefits in addition to the reauthorization issue, in that you're sort of outside the realm of RC adjudicatory problems. They're not looking at things like, well, do you have tenant occupancy jobs? Have you spent the money on qualifying expenditures? Are those appropriate uses of capital? All you have to do is demonstrate that the jobs are actually in place. And I agree with Julia that that can present a vast array of problems, the ones she mentioned. As well as what Jeff mentioned, which is that you have to demonstrate that those workers are qualified U.S. workers. You have to demonstrate that they are U.S. citizens, permanent residents, or otherwise have valid work authorization. And I would say that's one of the biggest problems we run into, which is that the service looks into whether or not those are qualified workers very deeply. And they ask for documentation that our employers are not required to get during the I-9 process or W-2 process. And those can sometimes put employers in contravention of anti-discrimination laws. So that's another thing that you have to worry about in those particular circumstances.
And the presumption is that the position was occupied by somebody who wasn't qualified. You have to prove that they were of legal status to work in that position. So that's another important thing.
I mean, I once put in
well,
an
I think
I-829 with 50 workers, and the USCIS spit back like 42, saying that their social security numbers were not on file. You know, so it's not a small problem.
No, not at all.
I think to sum up, there is an increase in direct or direct pull filings because of the uncertainty with the dealing with the regional centers. But I think most of us on this panel will agree it's easier to get the permanent green card through the regional center process. How's that for us?
No,
I won't argue, but I'm not bought in 100% on that.
No, but I mean, we've seen with the direct EB5 with the job creation. So, Julie, maybe we differ on this point, but you said that they would have to create the jobs. We would have to show the jobs for 8 years, as opposed to.
Well,
Well,
you
it
have
Just
to
for
show the
training.
jobs at the time of the I-829 filing.
And that's
Yeah.
a retrogression.
So yeah, exactly.
With
but
the retrogression.
it could be the position exactly. So would it? What if they created
the
the
whole
positions?
idea that the company still has to exist in 8 years versus a construction I love lively debates. Versus a construction expenditure job model where 3 years into the process, the construction is done. You just wait 5 more years. Again, I'm just playing devil.
So the moral of the story is get good professional assistance if you want to do a project.
Exactly. And just for context, because we have a lot of people new to EB5 here, like just numbers-wise, in fiscal year 2015, there were 9,764 EB5 visas issues, of which 156 were direct EB5s. So there's a lot of room for growth, definitely.
Another thing, the I guess negative side of the direct EB5 is that individual, a 5 to 6 process is 5 to 6 process. You have to have the source of fund documentation. You have to have the business documentation. And that doesn't change from regional center to direct small mom and pop. It's still, the business plan has to be comprehensive. It has to show that the jobs will be created, and then 2 years later, jobs have been created. So in order for you as just every, average EB5 investor to come into the United States where you're not really familiar with business climate and how to do things, to be able to put in a 500,000, and most of the cases it's million, because you don't know where the TEA is and all of that stuff. So, let's say you put in a million, and then if you are shortchanging yourself with, just average business plan that may not be EB5 compliant, you're losing. You're losing your investment, you're losing your immigration status. So it's not an easy thing to do at all for the direct component, which is why you have so few of them. It's not to say you cannot do it. I have represented clients from overseas that have had large manufacturing, company that would like to relocate here and can do it. And in those situations, the biggest hurdle is at the 8 to 9 stage, providing the W-2, and I-9s. For each position you created, you have to show that it has been occupied all throughout to the 8 to 9 application. So if there's any gap, if there's any minute little thing, USCIS is going to pick up on it. You know, as Julia said, oh, so-and-so did not have the Social Security number. I think all of us have heard of mismatch letters, Social Security mismatch letters. Up until, you know, a few years ago, that didn't really exist. E-Verify was not the issue, but it is now. So it just becomes harder and harder for average businessmen to come in and just set up a direct EB5 situation and get his green card and no problem. So,
So we've
Yeah,
covered,
so let's,
2 of 18 topics in the
I
first
know.
20 minutes.
I was like, okay, we need to go move forward to our next. I told you it was going to be jam packed, right? So our next question was regarding, and all of you please feel free, but can I purchase property and just purchase real estate with EB5 funds? We get this all the time, whether or not you can purchase it.
the requirement is active investment. Buying $1 million house is called a passive investment. So no.
So you actually have to, it can be used, but you have to actually show that there will be operations and that you will have job creation. So you can use it to show, but it has to show operations. Now, Jeff, in the regional center, is land used in the economic analysis?
Well, it's not used in the economic analysis, even though the expenditure of the land or an expenditure to get control of the land is allowable for use by EB5 capital, but the capital investment from the other expenditures in the project will have to carry the day for the 10 jobs per investor.
Okay, great. So we covered that one quickly. Anyone else has anything to add? All right, so I'm going to go into, I want to go into source of funds a bit. I know we haven't really touched on that topic, but we found some interesting facts. Lately, it could be both under source of funds or the project documentations, but USCIS has really clamped down, and we've seen an increase in denials. So in the last quarter of 2015, there were only about 337 denials, 377 denials, with about over 2,000 approvals. Now, for this fiscal year, we have seen those denials rise to 637. So I want to know what could be the issues and as to why USCIS all of a sudden in this new quarter have increased those denials.
Well, it's not all of a sudden. It's been brewing.
But it has doubled recently.
It's been brewing, and one of the biggest component is what we call the indebtedness policy, new policy that they decided to, or USCIS has decided to apply retroactively. A person who got a loan from a friend and invested into an EB5 program had been able to get approval. No longer. It has to be with a actual collateral. It has to be a secured loan, not a unsecured loan anymore. And the secure loan has to be with the collateral that you, as an investor, own, not someone else. So I think that was the biggest brouhaha of 2015, when a whole bunch of Chinese investors' applications were denied en masse, using this new indebtedness policy that was applied even before that policy was articulated. So.
I can add a little bit to that,
Yeah, go
Becca. You know, I can tell you inside both the Congress and the agency, there's considerable concern about these. Obviously, as Jinhee mentioned, the agency's concerned about it, but they're hearing very much what the agency is doing is mirroring ideas that have emanated from the Congress over the past few years. And the Senate EB5 reauthorization bill from June of last year, as well as subsequent drafts, all contained new restrictions on gifts and source of funds
Yes.
restrictions, both on gifts and loans, on collateral issues, on bank issues. When it comes to gifts, on tightening the circle of those who can provide a gift for EB5 purposes. So
Exactly.
we're likely to see this going forward. I think this is a legitimate concern for folks in not just USCIS, but other federal agencies.
Yeah.
Let me add to this. I think there's some unintended consequences that evolve from this stuff. I mean, on this morning's panel, somebody was talking about the changes in processing times for petitions and how it used to be pretty quick and money would sit in escrow and then money would leave upon petition approval, and how with the processing times that's no longer possible. So money is leaving escrow early, but 100% of the transactions that are out there are promising to repay the investor in the event of a denial. So you have these situations now where money is going out of escrow into projects, yet the denial rate is starting to increase. And so that has ripple effects on a number of different things. It has ripple effects, obviously, on the banking infrastructure, right? Because banks are going to be more nervous about being in the middle of situations where they've advanced money, understanding that there's a pledge to repay it that may or may not be able to be made, right? It's going to put strain on the developers in the regional centers who may find themselves in these difficult situations. So it just adds to the complexity of EB5. And I know we're going to talk more about escrow, but I want to make sure everybody understands, like, it's not just limited to the issues on the front end. There's downstream issues that many of the stakeholders are impacted by.
And just adding to what Matt said, I mean, this issue is on a lot of people's plates. Certainly, there's also pending litigation on this issue. I mean, it's clearly a misinterpretation of the statute, of the regulations. But for anybody who's a practitioner in the room, I was just going to note that, looking at your cases going forward, and even looking at the cases that you have that are already pending right now, we've found that there are a number of solutions that do work in these cases that might be helpful. One is certainly the indebtedness issue doesn't apply if you own the property with your spouse. USCIS clearly recognizes the concept of community property. Second, if the petitioner is not the borrower under the loan agreement, there's no indebtedness issue. It's a straight gift, and USCIS did say on its February 2015 stakeholders call, gifts are permissible. We found that to work in all cases. Third, this is a common scenario. A petitioner might own a piece of property with his or her minor child. That happens a lot in Chinese cases. In those cases, the service will approve those petitions because the legal argument is that the minor child lacks capacity to act as the mortgagor or the borrower under the loan agreement. And similarly, we have found cases where apparently it's common practice in China for banks to not lend to those that they deem to be elderly, which is oftentimes just individuals who are, say, 60 or older. And because of the legal impossibility of that person acting as the borrower under the loan agreement, the service will approve those cases. And the last case that we found to be approvable is where the petitioner owns a sufficient interest in the property to secure the loan. So, for example, if the property was worth 8 million renminbi and the petitioner owned 50% of that property, 4 million renminbi, that's enough to secure, the 3.7 million renminbi loan. And the other thing I would note in Chinese cases to keep in mind is that apportionment of property can occur outside of the actual property documents, like the registration certificate. So if there's a contractual agreement outside of those documents to apportion a certain percentage to the petitioner, those cases can be approved as well.
Well, Crystal, so what about the popular Chinese loans that they take from, like the company loans? Are those allowed? And at that point, what are they using as the collateral against it?
So that's a good question. So certainly we see a lot of shareholder loan cases. Shareholder loan cases are approvable, but unfortunately it's the same issue. You have to have enough equity in the company to secure your loan, or you have to take it in another form, such as from a gift from another shareholder. I will say that we have tried some novel scenarios involving for example, future proceeds of a company as security for the loan. And that's real. We all know that in the real business world, people use that as collateral all the time. But the service did not understand that particular fact scenario. And those cases that I had were not approved, unfortunately.
All right. So, well, just to go ahead.
I think that what we need to do as a practitioner is we're having to become much more conservative in terms of evaluating the source of funds and making sure that, the funds are starting from point X to Z and connecting each step of the way, the dot, and then looping back to make sure that the collateral that is being used is obtained, and then if that was a gift, it needs to go back even further. So what used to be 3 to 5 years worth of tax return and so forth could be 15 to 20 year worth of tax return. Just recently, I had to overcome a notice of intent to deny on a source of fund, which was shocking to me because I've never had it. But, this gentleman who has a large company overseas set up a company in U.S., was on an L visa. And in order to set up this company, he took a dividend from the company overseas. And the dividend was several $1 million worth. And he used that, and from the income source from the United States, he was able to fund the EB5. The USCIS's notice of intent to deny was, with what money did you establish the company 20 years ago overseas? And luckily, he had, before he took the small company to a larger company and started auditing, that auditing company had documentation that tracked how that initial company was set up with $19,000. So we were able to overcome it, but I had to sit there and say, okay, this is not necessary because you have tremendous amount of document of $2 million in dividend that he had earned that led to this investment and income of $300,000 or more that led to the banks and EB5. But since you're asking for this, here it is. But
and the burden of proof is...
Yeah, burden of proof had to be for us. I mean, just because, it doesn't win you a case to argue with the USCIS saying you're being stupid. So you have to, make your argument saying why this is not necessary, but if you can, do the conservative route to get the approval. So that just is, the climate.
There's definitely a policy shift on that about 4 years ago, because when we looked at the adjudication manuals, printed in 2010, I think. They were saying you only have to go back 5 years.
Yes.
Now we have to go back. We've gone back to like the 1970s, 60s. You have to start at the beginning.
No, you have to. We've noticed that we've had to go and all the way to the seed funds. So just to conclude this portion is that, just be sure that, the attorney, they will have to be sure that they get all the evidence that they can to be sure that your application will be approvable.
One other thing. For all of us who's working with the migration agencies, especially the ones that have been doing this for a while, these migration agencies tend to think that I have gotten approvals on these kind of source of funds. Why are you asking me for this? I get a pushback all the time. And as a lawyer, you have to educate the migration agencies. The climate is changing. USCIS policy changes all the time. And they don't even have to let you know that they have changed their mind. You find out by RFEs and NOIDs. So you know, you have to let the agent know and let the investor know who was, maybe misinformed by the agent, saying this is the way you should do things. And when you're asking the question, you have to explain to them that things are changing. And in order to get the approval, please prepare X, Y, and Z document further. And
So basically, don't let the investor or the agent bully you. Be firm. But I just want to go ahead and get into our next topic, which is a pretty ugly one, the R word of retrogression. I would say right now we're not technically, as Bernie, who is not here, but would say it's not really retrogression. What we're in is we have a visa backlog, which is only for mainland China. So the rest of the country, as soon as you get your approval, you're allowed to go ahead and apply to get your green card into the U.S. But mainland China has a visa backlog. And as we've seen, this backlog right now is about 2 years. We're at, they're only adjudicating applications for a green card that were filed before February 15th of 2014. And I don't know if you guys noticed, but the visa bulletin from this month hasn't changed at all. So Charlie Oppenheim from before had mentioned, he's from the Department of State, had mentioned that it would progress as we go along, but we've seen kind of a stagnant progression there. So now I wanted to go, so Crystal, if you wanted to go ahead and let us know, what is this thing about, we have chart A and chart B, what is that?
It's a good question. Just looking at the visa bulletin more generally, to introduce you all to it, if you're not familiar, the visa bulletin tells you when you can file an immigrant visa petition. The dates on the visa bulletin correspond to priority dates, and they let you know when you can file your petition. Generally, your priority date, meaning the receipt date on your eligibility petition, in this case, the I-526 petition, has to be before that date, before you can file your immigrant visa application. So generally, that's a Chart A date, essentially, which is meaning that if your date is before the priority date on the visa bulletin, you can file your 485 or your immigrant visa application, and the service will take immediate action on those petitions. They have also introduced the concept of Chart B, which is it's a filing date, meaning you can go ahead and file your immigrant visa application, whether it's a 485 application or a DS-260, but that doesn't mean the service is going to take immediate action on your petition. It just means you can file it. And it's important to note that, and I know we'll get into this a little bit more later on, but it's important to note that the filing under the Chart B date does not help in Child Status Protection Act cases, and I know we'll get into that a little bit more later on, but just important to note there.
Yeah, so, and also with Chart B, at this time, USCIS has actually closed it off for those filing for adjustment of status applications. So unfortunately, we cannot file adjustment of status. We could only file, I've only been able to file for my consular processing for the immigrant visa at that point. But I have been sneaky trying to get in the age out to help get the child who are going through consular processing. And I've noticed that the NVC has come back and has given me I can pay the fee bill, which is the fee that you pay prior to submitting your DS-260 application. They have produced it for the entire family except for the child who can potentially age out. So I've seen that issue, yes. And I think that it's very unfair. It's so sad to see that here my entire family is getting it and can move forward, and here I am still stuck. So yeah, it does not help the age out child at all. So that's another issue, Jinhee, right? The age out issue is.
Yeah, well, I mean, the rule says that you have to be 21, unmarried, and under 21 when the immigrant petition, in this case I-526, was filed, in order to hold that age. For rest of the world, it's fine. The minute the I-5 to 6 is filed, it holds that child's age at that point. And then when the 5 to 6 gets approved, you have to file a immigrant visa application DS-260 within a year. That gets you, and so even if you're 23 years old, when you're finally getting a visa interview notice, you're still considered under 21 and you're fine. But with the visa retrogression or the backlog of the visa numbers for mainland China, the minute 5 to 6 gets approved, clock starts ticking again forward. So although you were 21, under 21 when the 5 to 6 was filed, the minute 5 to 6 gets approved, you start aging again until you are able to get the visa interview. And if that waiting time because of the retrogression is 4 years, you're out of luck. So, which is why you have heard other panelists talk about filing for 13-year-old, 14-year-old, because we are expecting for mainland China the retrogression up to, some say, 8 years.
Yeah.
So-
Yeah, they said between 6 to 8 years.
Can we just add one more point, just to take a step back? There are 2 steps in getting a green card. One is you need to have an approved immigration petition. With that, you file for a visa or a green card, as they say. The I-526s that people are talking about is the first part, and right now we're talking about the second part. There are 10,000 EB5 visas a year. That doesn't mean only 10,000 people can invest in EB5 projects. So there's an unlimited number of people who can file for an immigration petition, the I-526. It's just that after that's approved, only a certain number of people can go to step 2. So just because I know there are a lot of developers here, I don't want you to confuse the investment piece. We're really talking about the visa piece, which is a separate issue.
Well, but for in all practicality, though, these EB5 investors are investing because they want that immigration component, the second step. And many of them are taking this step because of their children's education. They want the children to be able to come in with the green card, to be able to educate it, get a job, etc. If they cannot bring one of the children out of 3 or 2, they're not going to do it. So, you're going to have, you are looking at a population or investor pool that is very cognizant of taking both the 5 to 6 stage as well as the DS-260, which is why the Chinese retrogression is hitting this EB5 market very hard. The marketability in China has dropped significantly, not that much, but has dropped significantly since even last year, I believe. And so I think that your whole audience, when you are talking to an investor, you have to understand, as a migrant agent, you do anyway, but who's involved in the investor family, and how old are they, and et cetera, so that the investor does not have a false expectation. And just one other thing is that 10,000 visa numbers per year for EB5. It is not 10,000 investors. It is, it could be as little as 2,000 investors if every family member has at least 4 people or something, 4 or 5.
Yeah, so that includes
So
both the
it-
investor
it's-
and their dependents.
all the dependents. If Congress would actually drop the dependent numbers from the counting of the visa numbers, we wouldn't have this discussion at all. And this was an argument that was made to USCIS as well as Congress. Why don't we just drop counting of the dependents from the visa number cap? some say USCIS actually has the power to do that on its own. We shall see whether they will do that.
So that is one of the, I guess, what topics they're saying that what can be done to help this. Matt, what else have they been speaking about regarding what can be done to help retrogression when it comes?
This is a really tough issue, I think, for Congress outside of comprehensive immigration reform. On the one hand, we have a capacity issue with EB5, right? The demand is outpacing the availability of the visas annually. We also have a country quota issue, right, which is causing problems. And so it's a compound problem. I think on both issues there is, particularly in the employment-based categories, there's bipartisan recognition and desire to fix and increase capacity. I think for many members of Congress, this is sort of a no-brainer. Particularly with EB5, not increasing capacity is leaving foreign investor dollars on the table. And it just it's not good public policy. I mean, if we have a successful program, we have a popular program, we might as well maximize it. The problem is in Congress, among the Republican majority in both chambers, it is a golden rule that there is a pay-go when it comes to creating new green cards. So they have a pay-go rule. If you're going to create new green cards in one category, you have to take them away from another category. So you have to have a net neutral green card policy. That has been the case for several years now, outside of the situation where you have a lot of momentum for a big bill and different leadership in the Congress. But so I think there is willingness, for example, to take visas from the diversity visa lottery program and give them to EB5. I think there are many members who would support that. Certainly, I would think the industry would support it, but it will never get through the Democratic caucus in either chamber. So it is one of these things where, outside of the context of a big immigration reform bill, where everybody's quota and backlog problems are getting fixed at once in an equitable way, it's going to be very difficult to do it for one visa category, in my judgment.
Interesting. Well, I know one of this is spoken about in another topic, so I don't want to get in too much about the investors signing at the age of 13 and 14. But Reed, I wanted to get your opinion on it. With the whole escrow, what do you see going forward?
So this is a solution to the problem that's been sort of proposed by folks in the industry, and this is creating quite a bit of complexity in the financial markets again, right? Is that there's rules about minors investing in these kinds of things. And so what's happening is, while we in the industry can kind of think up these solutions pretty quickly, remember the financial institutions that are dealing with all of this capital are maybe the most regulated part of this country, and they can't adjust to these things as quickly, right? So you find yourself in situations where all of a sudden money's hitting a bank from a minor who's invested in a project, and that's outside the bank's policy. What's the bank going to do? They're going to kick that money back. Now imagine that money comes from groups of $50,000 and all this other sort of stuff, or it comes out of Iran, which is hard to get out. You can just imagine the complexity of this. So we've seen big projects go sideways quickly because they can't kind of get these investors into the project. So I think my advice is try to think through these situations in advance, and the financial institution that you choose to work with should be familiar with these issues and understand what their policies on are these things, because many of these things are just bank policy that they've made decisions to deal with.
All right. Well, so then I think we're going to wrap that one up and go into another hot topic that has a lot of talk in EB5, the TEA, which is the Targeted Employment Area. It's a fun topic. Jeff, I'm going to have you take that away.
I was going to have a test. I was going to ask everybody what TEA meant, and you blew it. So now let's move on to the next topic. I don't want to do that. But anyway, here's the skinny on TEAs. We've talked a little bit about them. We've kind of beaten around the bush in other panels on them. But basically, Targeted Employment Area TEAs, really what it does is it simply defines whether or not your investors have a minimum investment amount of $500,000 if they're in the targeted employment area, or whether if they're not in a targeted employment area, they have to use the $1 million default amount in the program. Now the problem is, since the first four motivations of your investor is to get immigration benefits, the second one's to get immigration benefits, the third one's to get immigration benefits, the fourth one's to get immigration benefits, the fifth one is maybe giving a little bit for tying my money up for 7 or 8 years. And then at the end, try not to lose my principal. So if the primary benefit for the immigrant investor is to obtain immigration benefits, you want to be a $500,000 investment minimum project, because nobody's going to pay you roughly double to get the same immigration benefits they can get from dozens of other projects in the marketplace at $500,000. So right now, the current law, which nobody really knows how long it's going to endure, you can become a targeted employment area 2 ways. You can be located in a rural area in the country. And by rural area, they mean it's a negative test. You are not located in one of the 380 some odd metropolitan areas in the country. So you are either in or you are out. There's no partially in, partially out. So if you are in a county, they're defined by counties, that is located within a U.S. Office of Management and Budget designated metropolitan area, you can't be a rural TEA. Now, a rural TEA is great because it lasts for a long time. Because the only other requirement, if you're not located in a metropolitan area, that you have to have is you have to be in a municipality, a city, a village, or something like that, of less than 20,000 residents, as indicated by the most recently completed 10-year census. So that's April 1st of 2010. So the good news is, unless the OMB changes the designation and the design of metro areas, they do that periodically. Last time they did it was in April of 2013. And they put your county in a metro area. If you are in an area that's rural, you're usually good to go for 10 years. If you're not in a rural area, the only other way you can qualify is if you're in an area that's in distress, located in a metropolitan area, like in New York, which means that you have to be in some area, and there's several different types of areas, where the unemployment rate, according to the way the state calculates it, most states, including New York, use what I call the trailing calendar year annual average. So we're in 2016 right now. Right now, the states are using annual averages for calendar year 2015. Most of them are. If you're in Arizona, they use July 1st to June 30th and all that kind of crap. So you got to be careful if you're doing a project that you don't know about. You have to, in the state you don't know about, you have to confirm this. And you have to have an unemployment rate that's at 150% of the national average unemployment rate. Now, as we talked about in other other panels, right now the USCIS defers to the geographic configurations of targeted employment areas that states approve. Now, it's pretty easy to do it if you're in a county that has an unemployment rate of 150% of the U.S. average, you're fine. There's no states now that have 150% average of the unemployment rate average. There's no metropolitan areas that I know of that have an unemployment rate of 150% of the U.S. average. So you can look at county, you can look at the municipality, the town, village, or city. If that has an unemployment rate of 150% of the U.S. average or higher, you qualify. But even if you're in a municipality that doesn't qualify, you can go down to a level called census tracts, which are defined by the Census Bureau, which are generally, certain increments of the population within the municipality. And I've even gotten them for census block groups, which are smaller divisions of even census tracts. And the whole controversy about TEAs has been, there's no really set policy about if your project is not located in one of these census tracts that qualifies all by itself, you can bring in other census tracts around it and blend the unemployment rate to see if you can define an area that meets that test. And that's really important because, as I said before, you don't want to be a $1 million project in a $500,000 market. So how do you like it so far? The real issue here is that the reason for TEAs back in the early 90s, when the program was a small child, the senators wanted to incent money into rural areas because rural areas, let's face it, they're not capital rich. They're a little starved for investment capital. So one of the ideas of the program is rural areas aren't as well known as New York and Los Angeles and Miami. So let's do something like reducing the amount that the investor has to invest in order to encourage capital to go into rural areas. Now, all the other arguments notwithstanding. But recognizing that deal flow isn't all that robust in rural areas, Chinese investors are not looking to invest in East Podunk, Iowa. They like New York and Chicago and Miami. So the founders of the program also said, let's let them invest in metropolitan areas that they might prefer, but let's allow them only to reduce the investment amount, the minimum investment amount, into areas where there's stress, economic stress. So they allowed people to do these things in areas of economic distress that met and they define that by areas of unemployment that are 150% of the U.S. average. And so what's happened is that USCIS doesn't have the capacity to adjudicate all these, so they've given it to the states. The states want to attract capital investment money, and so we've gotten these TEA areas, and because the program requires all the census tracts to be contiguous, that look like amoebas and spiders and all the things, and they've called, the technical term has been called gerrymandering.
Yeah,
Of
that's why we
TEAs.
have so many of those in New York City.
Yes. And, I always say gerrymandering is in the eyes of the beholder. To people who don't like a project, they think the TEA is gerrymandered. To the
Yeah.
people who are sponsoring the project, it is a thoughtful, beautifully crafted area.
It's actually not the technical term, it's the pejorative term. For what
That's correct. So right now, there's a lot of discussion about how we can get back to congressional intent. There's a lot of discussion in EB5 reform. I will tell you that two things are going to happen. Number one, the investment amounts aren't going to stay the same. They're probably going to change. Whether or not the gradient stays at $500,000 or gets narrower, we don't know yet. And I will guarantee you that any reform bill that finally comes out, whatever that is, maybe 5 years from now, who knows, TEAs will not exist in their current form, if they exist at all. There is a school of thought that says TEAs, the heck with them. I happen to subscribe to that notion. I think TEAs are much to do about nothing. There are things that we can do to encourage investment into economic areas of distress in rural areas without TEAs. And what we're doing is we're strangling ourselves in this fight. It's dividing the industry, it's dividing the politicians, it's dividing the staff that are crafting the various legislative language to have the program go forward. So I say, screw it, get rid of them. And then just have some kind of gradient. And if I was king, going back to Mona's thing, if I was king, we do away with TEAs, we make the investment gradient difference to encourage and incentivize people, something like 100, 150, 200,000, and we create incentives for investing in rural areas using maybe even our current definition without the unemployment rate. Even though, excuse me, in rural areas there's no unemployment rate, even without the limitation on residents. And then we would provide separate sets of incentives for doing infrastructure investments and maybe some other types of investments and types of projects that would benefit the public good and still meet the criteria of creating jobs and produce enough liquidity so that the investors can get paid back. But that's my wish, Mona. I think that doesn't stand a political snowball's chance in Hades. They're getting taken care of. But that's how I would fix it.
You haven't.
Just to add to that, because we have projects in Manhattan. I mean, the entire island of Manhattan is a TA. I don't think there's any place in Manhattan that will not get TA status.
Well,
And
of course, some will argue that none of the area in Manhattan will fall in the technical term of TEA because it's not 150% of the national unemployment area. However, it has been gerrymandered. This is not my words. This is what they say. Gerrymandered to make it into a TEA by using the waterways surrounding the island.
and
one or
also
the
there's
other.
Central Park, and then there's because it's
Yeah.
really.
But let's be real here. Let's be real here. The only reason why TEAs are gerrymandered is because the USCIS doesn't use any economic logic in saying that the areas have to be contiguous.
Exactly. Yeah.
It doesn't take into account where people live who
Yeah.
come to work at these projects.
Community.
And as long as we're going to throw economics out the window, okay, on this and get into politics, this is why we have a big division. And this is why the Congress has been able to divide the industry to keep meaningful reforms from progressing to the detriment of the program.
Okay. Well, as much as
just 2 points.
Okay.
Just 2 points. No, I'm
would
not
love
going to
to-
engage in a lively debate. It's a losing debate.
Oh,
for
come
me.
on, Julia.
No. But I just wanted to so the broader audience understood. There's this misconception that if it's a direct EB5, it's $1 million, and if it's a regional center EB5, it's $500,000. That is not the case. It's the location of the project that determines the minimum investment amount. And just to give some context to it, out of the 9,764 EB5 visas issued in fiscal year 2015, only 75 of them came from $1 million projects. So a lot of people think my project is so great, so even if it's 1 million, people will come to me because I'm on 47th and Lex, and yeah, that's our project. But that's not the case. You have to be qualify as a TEA. And I live in Bergen County, New Jersey, and because of the way the rules work, New Jersey, northern New Jersey, just can't get a TEA. Because too many people live there, whereas in Manhattan, not that many people live here. So it's a sensitive issue.
All right. Well, as much as we would like to continue with the TEAs, I would like to get Reed. He's probably feeling lonely down there. If you can go ahead and just quickly on escrow and how important it is.
So first of all, there's no legal requirement in EB5 to use escrow at all. So why would you do it? You do it for a couple of reasons. First of all, there's been a promise made to the investor that in the event the petition is denied, that they're going to get their subscription money back. So escrow is a logical way to have that money available in the event that the petitioner is denied. And that has a marketing impact. So that's the other reason you would do that, right? Is because the investors like that additional security. So it's going to make selling the project easier. You know, we've done a lot of projects and we've been able to correlate a relationship between the sort of conservative nature of the escrow terms and how quickly projects fund. And what we found is when you look at folks who are relatively new to the industry, which is the vast majority of the projects that are out there, the more conservative they make their escrow structures, the easier it is to sell the project. And that makes sense, right? Because, you know, folks are nervous about the investment. Some investors are going to demand this, so it means you have to talk to more investors if you don't have escrow. Your marketing costs go up, on and on and on. So that's why you would want to do it. Now, why wouldn't you want to do it? Because it's hard. There are 6,000 and some odd banks in this country, and there might be 12 that will hold EB5 deposits on a consistent basis. And so why is that, right? Well, banks are run by the risk and compliance departments these days. So a lot of you have a neighbor next door who's a banker who you're going to say, hey, would you take my EB5 money? And that banker is going to say, heck yeah, because it's a big chunk of money and it's going to sit for a long time. And you're going to waste all this time and energy going down that path only to find out that the risk and compliance department of the bank is going to say no. And then you're going to get into a big pile of trouble. Or even worse, that banker manages to get the account open somehow. Now there's money pouring in from all over the world, and the risk and compliance department goes, what the heck, get that stuff out of here. And so now you've got to close down the account, move the money to another one, and on and on. So it's hard, right? And in the grand scheme of things, banks aren't like they used to be. You know, they're well deposited. They're not lending like they used to be. So the demand for deposits isn't what it used to be. And so they can be selective, right? EB5 in the grand scheme of things, let's just imagine it was 10,000 investors for a moment. That would be $5 billion a year. And if you're Bank of America, why would you deal with all of this potential foreign investment, anti-money laundering stuff to deal with, OFAC screening, blah, blah, blah? Why would you deal with all of that for some portion of $5 billion if your total deposit base is $1 trillion, as an example? You just wouldn't. And so what you find is it's really, really selective about what banks will take. And even amongst the ones that will do it, they all have different appetites. Some won't take money for casinos, as an example. Another one won't have anything to do with we had one customer who was doing a hotel adjacent to a gun club. No, wouldn't take that, right? It's a hotel project, but just because it happens to be adjacent to a gun club, they won't. So there's a lot of these nuances you have to work through. So that's one reason you wouldn't, is it's hard. The other reason is because it's slow, right? Introducing an escrow into the process slows down the speed of which that money can move into the project. And this is a real problem, right? Because the projects have construction schedules and timelines that they have to hit. And of course, the investor wants that money to sit there with certainty until the petition is approved, and so you've got this disconnect. I did some modeling a little while ago, and what we found is in 2010, 100% of the escrows we were doing were going in and sitting there until that investor's petition was approved. And the processing times in that era were about 4 months. Now processing times are like 18 months or more. And 96% of the escrows we do are what you would call early release. So early release by definition is when some portion or all of that money leaves the escrow account prior to approval. And so that introduces a whole bunch of complexity around, well, if you're releasing money earlier, like I alluded to, how do you protect the investors and how do you protect yourself to make sure the money's available to come back? And there's a variety of different algorithms and structures, and this is where it gets really important to use the right team, because if you don't set up the language correctly, it could look to USCIS like the full investment amount wasn't actually made. And so that can be problematic. And so we've been trying to find innovative and newer solutions. There's some folks that will do corporate guarantees. Increasingly, some of the developers coming into the space have the balance sheets to be able to guarantee a $60 or $100 million project, but the vast majority don't. We actually thought the perfect solution would be an insurance product, because if you had insurance so that would repay the investor, that's what the investor wants. And you could give 100% of the money to the developer. So there's an insurance product that we've come out with in partnership with an insurance company to be able to do that kind of stuff. So there's a lot of innovation and opportunities for that and ways to get through this, but it's important to work with the right team. And the final point I'll make is that the escrow is just the beginning, right? That's just the initial process. These investors are in this thing for, well, now 7-8 years or so. And when you think about what the investors are doing, they're investing in a fund, right? So they're making an investment it's a private placement in a fund. And those investors deserve the same type of service and reporting and transparency that any of us would want or expect when we invested in a mutual fund or what have you. Flash back 6 years ago, that was sort of a concept that really wasn't understood. It was all about, let's get the money into the project and thank you very much. But there's so much documentation, so much reporting, so much tracking required to prove exactly that the money was invested in the right things and it was invested as per the business plan and the jobs were in fact created. And so there's a tracking and reporting capability that needs to be implemented. So those of you who are thinking about becoming regional centers, make sure you put in the operational infrastructure or partner with somebody who has that to be able to remain compliant with both the investors' needs as well as the services needs. And I know we're running out of time.
Great. Yeah, I know. I'm so sorry. But as much as we would love to discuss more unique issues in EB5, we haven't even touched on some of it. But we're going to have to go ahead and break. And we're all here for the reception. So please, if you have questions, come to any one of us. And thank you again. Thank you, panelists.